Good afternoon, and thank you for joining us for this press conference by Mr. Ben Emmerson, the Special Rapporteur on the promotion and protection of human rights while countering terrorism. Maybe we'll start with some remarks by Mr. Emmerson, then we'll go for some questions. Thank you.
Well, the central message of the report that I presented this morning to the General Assembly is that mass surveillance of the internet poses a direct challenge to an established norm of international law, that is the right to privacy under Article 17 of the International Covenant on Civil and Political Rights. Article 17 carries with it the basic principle that individuals have the right to share information and ideas with one another without interference by the state, secure in the knowledge that their communications will reach and be read by the intended recipients alone. Measures that interfere with this right, and it can be interfered with, must be authorised by domestic law that is accessible and precise, and they must be proportionate to a legitimate aim and meet the test of necessity. The central distinction drawn in this morning's report is between targeted surveillance, that is the situation where a state authority has a prior suspicion of a particular individual or organisation and sets about to investigate their activities, and mass surveillance, whereby states are able to secure bulk access to communications and content data without any prior suspicion. States currently engaged in mass surveillance programs are now able to apply automated data mining algorithms to dragnet a potentially limitless universe of communications traffic. By placing taps on fibre optic cables through which the majority of digital communications travel, these states have been able to conduct mass surveillance both of communications content and of metadata, providing intelligence and law enforcement agencies with the opportunity to monitor and record not only their own citizens' communications, but also the communications of individuals located in other states. The use of scanning software, profiling criteria, search terms, and automated data mining algorithms enables the authorities in these states to filter vast quantities of stored information in order to identify patterns of communication between individuals and organisations. What then is the justification for this? Well, the prevention, suppression and investigation of acts of terrorism are clearly legitimate aims within the meaning of Article 17 of the Covenant. They can, therefore, in principle, justify even mass surveillance of the internet, providing certain criteria are met. Terrorism, we know, is the suppression of terrorism is a public interest imperative of the greatest importance. Terrorism can destabilize communities, threaten social and economic development, fracture the territorial integrity of states, and undermine international peace and security. So there may, in principle, be a justification for mass surveillance of the internet. But the acts of intelligence agencies must still comply with international human rights law. A mere assertion, without evidence, without particularization, that mass surveillance technology can contribute to the suppression of terrorism is not in itself enough. The fact that something can be done, that it is technically feasible, and even the fact that it may, on occasion, yield useful intelligence, doesn't by itself mean that this type of technology, with its extraordinarily wide reach, is either reasonable or lawful. As an absolute minimum, Article 17 requires the states that use mass surveillance technology on the internet to give a meaningful public account of the tangible benefits that accrue from its use. Without that form of justification, there is just no way of measuring the compatibility of this practice with the requirements of the covenant. So the twin elements are transparency about the nature of internet penetration by a state and an articulable justification for its use. Of course, in the end, as with all issues of national security and civil liberties, any assessment of the proportionality of this new technology involves striking a balance between the societal interest in the protection of online privacy on the one hand and the undoubted imperatives of effective counter-terrorism and law enforcement on the other. But we have reached a point at which it is now essential for states to squarely confront the reality, which is that mass surveillance programs do away with the right to internet privacy altogether. The use of technology which is capable of capturing all data all the time, indiscriminately, is plainly incompatible with the essence of the right to privacy as we have understood it until now. Anyone who wishes to participate in the exchange of information and ideas in the modern world of global communications is nowadays obliged to use transnational digital communications technology. And so the extent of the interference is obviously very great indeed, and it needs a justification of analogical magnitude. Fundamentally, in addition to providing a public justification so as to promote a debate within and between states, there is also an obligation expressly imposed by Article 17 of the Covenant to have a clear, precise and accessible legislative framework in national law. Very few states, including the states using this technology, have provided an articulable public justification for assessing its proportionality, and almost no states have adopted specific legislation authorizing its use. Instead, outdated generalized legislative provisions are adapted through secret interpretations to authorize the use of a form of technology that was never envisaged when the parent legislation was enacted. So the first critical requirement is for an updating of domestic legislation, and the second, which goes hand in hand with that, is the need for effective independent methods of scrutiny and supervision, both before an interference takes place, before surveillance occurs, and after the event, mechanisms that are adequately resourced and capable of evaluating this type of technology and its use in particular instances, not just against the requirements of domestic law, but fundamentally against the requirements of necessity and proportionality that are laid down in Article 17 of the Covenant.
Thank you, Mr. Emmerson, for those remarks. So, questions? Maybe we'll start here. We'll come to you afterwards. Please.
Hello. You mentioned that you would...
Just a suggestion, if you could state your name.
Oh, I'm sorry. Joelle Metcalf with the Asahi Shimbun, a Japanese newspaper. You can go first.
I'm so sorry. I was typing the last thing you said and didn't pay attention. Let me welcome you. I'm Evelyn Leopold. Let me welcome you on behalf of the United Nations Correspondents Association. And thank you for your briefing. And I'd like to ask if you could name the states that have the mass surveillance, and then can the suspicions, the ones who have suspicions of certain email transactions or websites. Can that be used, for example, to against a human rights advocate or things that would go against the principles of the United Nations?
In answer to the first question, name the states that use mass surveillance technology, I should preface my response by saying that there is a distinction to be drawn between those states about whom it is known that there is mass surveillance technology in use because for one reason or another it has entered the public domain, and that would of course include the United States, the United Kingdom, and the other states with whom they closely cooperate in intelligence terms, because whilst those states may not themselves have the technical capabilities to conduct mass surveillance of the internet, the process of intelligence sharing, for example, between the Five Eyes community associated with the US and the UK, will mean that that data is then available to other states in the form of information exchange. We know much more about the programs operated by the United States and the United Kingdom than we do about the programs operated by other states. And that is partly, of course, because of the revelations of Edward Snowden, published in the Guardian and the Washington Post, which provoked a public debate both in the US and the UK, and to some extent has galvanized the administration in both jurisdictions to provide voluntarily further public information about the nature of the programs they operate. I don't think anyone should be under any illusions that all of the relevant information is in the public domain, because I think that would be a great mistake. I think even within those two states there are programs in operation which are not yet in the public domain. But certainly it is the position that a number of other states, one or two in particular, have an analogical capacity for internet penetration. Whether or not they operate the same or similar programs remains to be seen, because the information just isn't there. It is there. It's not in the public domain. Targeted surveillance, of course, is only as good as the rule of law principles that are applied by the authorities that are using it. There will always remain a risk that on the pretext of countering terrorism, states will conduct forms of surveillance which have nothing to do with terrorism as we understand that word. Part of the problem is the penumbra of uncertainty that surrounds the very definition of terrorism. And as you all know, the UN has no agreed definition of terrorism, which leaves a wide latitude to states to decide what their national security interests require. And one of the great difficulties of having inadequate legislation, inadequate supervision, and inadequate transparency is that it is impossible to know whether or not such intrusive mechanisms as are now available, mechanisms that enable states to take over control of your computer, to override its settings, to turn it into a permanent eavesdropper on your activities within your own office or home, to send messages that appear to have come from you, or for you to receive messages that appear to have come from someone else, or even for you to visit such common websites as the Google search engine and believe yourself to be using the Google search engine when in fact you're using a clone website set up by states to look like the Google search engine, which is capable of then infecting your computer with malware, which enables it to act as a permanent spy against you. So,
who has done that?
well, you'll see if you read the report, and of course, I'm careful in the report not to cite as fact that which is only a report. But there are reports that the United Kingdom's GCHQ and the United States NSA have the capacity to adopt what you call chameleon websites, or chameleon communications, which imitate the behavior of others. Now, the nub of your question was, is there a risk that this will be used against civil society space, against human rights defenders? That is the same risk that is present whenever states seek to close civil society space on national security grounds. The difference here is that there is an ever-present risk of purpose creep, whereby states enact legislation on the pretext of countering terrorism and then use it to enable a wide range of public authorities to conduct surveillance for much less compelling public interest purposes.
Follow
Maybe
that for 1 second.
One second,
Yeah.
Evelyn. We'll come back to you. We will go to someone else, please.
You mentioned the recommendation that a special rapporteur mandate be created for this specific issue. Would you want them to concentrate solely on government data mining, or would they also look at private sector data mining as well? I also wanted to ask, how do you view that the two might even converge towards a lucrative partnership for both sides that may violate the right to privacy with less incentive to comply?
The two being state and private. Well, in answer to the first question, as the question implies, there is an inevitable partnership between states and private enterprises in the monitoring of digital communications. Some state surveillance can be conducted without the direct involvement of service providers, but classically states will impose legislative obligations, so they'll enact laws that oblige internet service providers to retain metadata, that is data recording communications, where they've come from, where they've gone to, how long they lasted, not just direct telephone communications or email communications, but visits to websites and so on, all of which enables a profile to be built up about an individual. The effect of that legislative frame, or those legislative frameworks, is to require internet service providers to retain that data in order to make it available for dragnet data mining. So that's the first and most obvious way in which private enterprises end up contributing. But there are also reliable reports, as you will be aware, of private enterprises entering into agreements with government to incorporate vulnerabilities in their systems software so as to make it readily available or readily translatable into a system which can be penetrated by surveillance. In other words, making software systems wiretap ready. Now, the view that we take in the Office of the High Commissioner, and you'll find this in the High Commissioner's own report on digital privacy rights and in my report, is that the obligation to secure the right to privacy, of course, rests primarily on states, but includes obligations that apply to private entities. And the principles laid down by the special expert on the obligations of private enterprises, the Ruggie principles, on the requirement of states to comply with the requirement of private entities to ensure that their operations comply so far as possible with respect for the promotion and protection of human rights, have a direct impact on the operation of service providers, and that's touched on in my report, and it's elaborated in more detail in the High Commissioner's report.
One question from Matthew Lee, and then we'll go around the room.
Sure, thanks a lot. Matthew Lee, Intercity Press, on behalf of the Free UN Coalition for Access. Thanks a lot for this briefing. I wanted to, your report talks about the responses by the Obama administration convening this privacy and civil liberties oversight board and legislation. I just wondered, can you say the positions that you're coming out with today, how far does the U.S. have to go? What do you think of the steps that have been taken? And given your mandate, I wanted to ask you about the Security Council passed a resolution in September about foreign fighters, and specifically in relation to terrorism. And I just wonder, as the UN system's kind of expert in this field, do you think it raises civil liberties issues for those that could be swept up in it? Thanks.
So those are two very different questions, although there might conceivably be, in practical terms, an overlap between the two. I've obviously followed in detail the steps that have been taken in the United States. And it's fair to say that, at least initially, there was a greater degree of public interest and concern about the Snowden revelations in the United States than there was in the United Kingdom. Clearly, the administration has taken important steps to get to grips with the problem, and has taken seriously the concerns that have been expressed, both within the US and beyond, about the privacy implications of the principal US programs. And I think it was an important and serious and sensible response to set up or to refer the matter to the CLOB, and their two reports bear very careful reading. But there is still some considerable way to go, and leaving aside the detail, there is a fundamental problem here where unstoppable force meets immovable object. The fact is that this type of technology is proliferating, and it will carry with it an impetus for ever greater appetite among states to obtain and analyze data. It is inevitably corrosive of the right to online privacy, to the point where it cuts into the very essence of the right. Now, you know, for that to be the position, a debate that takes place around the edges, around the detailed fringes, continues to distract attention from the central problem, which is, are we, as democratic societies, in the plural, willing to accept the complete abrogation of the right to the privacy of communications through the method that is now most commonly used by everybody all over the world on the grounds of national security and prevention of terrorism? Well, how can that question be answered if the states that have the answers refuse to provide them publicly and continue to maintain, therefore, a conceptual censorship over the very key question of necessity and proportionality that needs to be addressed by communities as a whole? And that's why I've said primary legislation is the only way forward for states, so that there be parliamentary debate through representative democracy, so that governments using this technology have to justify specifically what they're doing to their own electorate, so that there will be some transparency and some collective responsibility.
We'll take a question in the back and we'll come back to you. Please. Yes.
Yes, Stefano Vaccara for La Voce di New York and Radio Radicale in Rome. Thank you for this, because it's very timing. I have this question. First of all, the Universal Declaration of Human Rights in Article 12 has been always accused of being a kind of a Western values declaration, and so many states, for example, didn't apply many articles, and there was always said because that. Well, in this case, Article 12 and the right of privacy. 17. Okay. 17 and the right of privacy it was like referring to privacy, and in this case, like you explained very well, country that have a technology, Western country, democracies, and so on, abuse this right. Now, my question is, first of all, you think it is strange, but do you think that you're being watched while you were doing your investigation? And secondly, if you think that in legislation that you're talking about, if there should be also something that prevent those countries to sell technology to other countries to implement this kind of spying on their people. So, because if you can also no spying anymore on your people, but you still sell the technology.
The answer to your first question is yes, I always work on the assumption that my communications are monitored, rightly or wrongly. I think that in the modern age, even with sophisticated encryption packages available, it's a reasonable assumption that those who are involved in matters of international relations that may have implications impinging on core interests of state have to assume that their communications may be monitored. That's simply on the basis of the fact that we know that the communications of many people in that in the international sphere have been monitored, and that there is evidence of attempts to conduct systematic monitoring on representatives at the United Nations as well. I actually haven't given detailed consideration to the suggestion that you've raised in relation to domestic legislation and the possibility of imposing an export ban effectively. But I don't currently see that that is realistically on the horizon, because first of all, those states that have this technology do not accept that its use is per se unlawful, of course, and therefore would be unlikely to impose a blanket export ban on its being supplied to other states in general. I mean, states can't very well say, we have this technology which we continue to use, but we won't export it to others because it's unlawful to do so. But of course, the natural version of export control is political allegiances. That is to say, one would not expect certain states to share their technology and their technological advantage with anybody other than their allies. And I gave you the example earlier on of the Five Eyes community, the United States, United Kingdom and Canada and so forth, where there is an active process of sharing even the most sensitive intelligence derived from this type of technology. And of course, you don't need all states within the Five Eyes community to have the same technology, providing some have and share the information that they have. So I don't immediately envisage export bans as being a realistic way forward. Far more important at this point is getting transparency, justification and legality resolved.
We don't have much time left, but we'll be able to take a few questions. If you can go straight to the question, that would help. Here,
Nizar Aboud of Al Mayadeen Television in Lebanon. My question is regarding how reliable are metadata when it comes to courts of law, given what you have said, that every communication could be eavesdropped on. And but still, I mean, in many courts, even international courts, they rely on metadata in establishing whether this person is incriminated or has any ties with a specific crime. Do you feel that this is still valid in this modern Orwellian age?
Yes, as I said at the outset, I'm drawing a firm distinction between targeted surveillance, where an individual is suspected and then their communications are surveyed, and that might be surveillance of the content or it might be surveillance of the metadata. which is no different fundamentally from conducting any other form of investigative measure against an individual who is being suspected, providing the relevant threshold tests are met. Is there a suspicion? Is this a proportionate response? I mean, it's very different if you use internet surveillance against someone suspected of terrorism against if you use internet surveillance against someone suspected of not paying a parking fine. So proportionality will always have a role to play in that process. Well, I think that probably answers your question, doesn't it?
Well, I can explain it further. For example, you said, and I feel it sometimes in my phone, somebody calling me, I received a call from you, and this happens once a week or so, which I've never done a call.
Mm-hmm.
In the meantime, it's very easy to stitch someone by making a call, a pseudo call, or something inventive, and then bring that up
I see.
in courts, which we have instances of that happening in some international tribunals, in fact.
Yes. Well, I mean, I think that cell site analysis is what you're referring to as evidence in court, and I think you may be thinking about the Lebanon Tribunal and the prosecution there as an example, which relies heavily on cell site analysis.
Yes.
I mean, as you rightly say, cell site analysis has become an important evidential tool in prosecutions in many jurisdictions for the most serious crimes. And to the extent that there is evidence of its vulnerability, then that obviously needs to be taken into account by the tribunal that is deciding the case in evaluating the importance and relevance and probative value of cell site analysis. But I don't think there's any suggestion that it's an inherently flawed method of investigation. It may be that it throws up anomalies in certain cases with certain particular calls, but even that is capable of forensic analysis in order to expose when things have gone wrong. But I wouldn't suggest that the findings of this report undermine the value in principle of using cell site analysis as an important evidential element in criminal prosecutions.
Well, in case
Maybe-
of voice, for example, it's not acceptable. Recordings, audio recordings are not acceptable in courts because of the possibility of being manipulated.
Mm-hmm.
Why would such cell site analysis be accepted, given that they can be also...
The short answer is it can be any potential, the whole purpose of judicial proceedings, if they're fair, if they meet international standards, is to expose the strengths and weaknesses of evidence. And there's in just the same way as a voice recording can be analysed for relevance, and there is no rule that universally that prevents voice recordings being admissible, but if there's a challenge by the accused to whether that voice on the tape is hers or his, then there will need to be expert evidence and competing analysis to determine that. So it's the same. It's not fundamentally different. If there's a problem, then it ought to be capable of being identified through a properly resourced criminal process that meets international standards and enables the accused to instruct experts and so on.
One last question in the back.
Okay. Caleb Maupin, correspondent for Press TV. Our network, Press TV, can only be viewed in the United States and the European Union on the internet. It's been, because of legislation, it's been banned from satellite broadcasts. And in the United States, if you want to view Press TV, if you are using the wireless from a Starbucks or a McDonald's restaurant, you can't do it. And today's Wall Street Journal just reported that a meeting took place between the government of the United Kingdom and the owners, representatives of Twitter and Facebook and other social media, saying that they wanted to combat what they call and vaguely refer to as extremist views. Now, in addition to the surveillance that you've kind of exposed, what is the potential for suppressing contrary views and the intrusion of the governments into internet and suppression of views contrary to what they would like to be heard?
It's an important question, but it covers a very wide substantive scope. because suppression of extremist views, it depends upon who is deciding on whether a view or an organisation is extremist. So classically, the debate would be about closing down websites that are recruiting to jihad or to ISIS, or manipulating them in order to provide different messages or counter-propaganda and so on. That type of internet manipulation is now the daily bread and butter of the intelligence agencies on both sides of the Atlantic. And that may involve all forms of manipulation, as well as, in an extreme case, the closing down of websites. But in fact, the intelligence agencies in the UK and the US are more interested in observing who is coming and going on the internet than they are in closing them down. Whereas, as you'll be aware, censorship in other countries, in China and Korea, often involves the closing of websites or the closing of whole parts of the internet. I mean, we saw reports during the unrest in Hong Kong recently that attempts were being made within China to prevent the Chinese population from having access to news about that. So, I mean, that type of if you like, I mean, some would call it censorship, others would call it internet control, is a feature of a significant number of states. I am not personally aware within the US and the UK of attempts to close down lawful speech as opposed to unlawful speech. And I think in a sense, if one is talking about extremism, the distinction that I would draw is between speech that falls within the range of lawful free speech, which may include a wide range of views and opinions that are objectionable to others, on the one hand, and speech which crosses the line into incitement or race hatred on the other.
Thank you very much, Mr. Emmerson. We'll have to leave it here because another press conference comes after this. At 3 p.m., there's also another press conference by another special rapporteur, Christoph Heinz. Thank you.